You're listening to Lawsuit Proofing Your City, a podcast with Scott Grossberg. Each week, we explore current trends in lawsuits brought against cities and give you tips, tricks, and techniques for fighting back. And now, here's your host, Scott Grossberg.
Welcome back, everybody. Today we're going to talk about a subject that's near and dear to my heart in the litigation world, and that's the situation where opposing counsel just name a plethora of defendants, irrespective of whether they're responsible for an alleged incident or not. They will name cities and towns and agencies, even if that city or town or agency didn't do anything wrong, and in some cases, even when it's not in the jurisdictional boundaries of that agency. I'm going to say that again. We're dealing with litigation today where you're getting sued even if the event didn't happen in your jurisdiction, and only because you are somehow in a contiguous location to what allegedly occurred. That seems to be enough for them to just sue today. And if you're a county, lucky you are now getting lumped in with everyone in contiguous counties. The attorneys that I'm seeing doing this are, in my opinion, usually non-responsive, lazy, and somewhat scared. In fact, this really is just another fishing expedition ploy for them. They're just throwing stuff out there and seeing if anything sticks. When I use the word scared, we're usually dealing with attorneys who are afraid that if they don't name a defendant, they're going to be sued by their own client. By the way, that should tell you what kind of lawyer they are and how they filter and vet and take on their clients. I've even had this situation arise, and when I contact opposing counsel and tell them it didn't happen in my city, it didn't happen in my town, my agency wasn't involved, opposing counsel merely replies back to me, file a motion for summary judgment, I won't oppose it, and at least I can get a court order that I go back to my client and blame it on the judge. The bigger issue for me is that I am now seeing, frankly, some really good lawyers taking the shotgun approach. And when I contact them and ask for a dismissal, they're telling me, well, Scott, the dismissal is worth something, even if the case is frivolous, even if the case is meritless, even if the incident didn't happen in your client's jurisdiction, it's worth something. And let's just talk about nuisance settlements now. I don't need to tell you, all of this can become extremely costly in terms of time and money and personnel. I mean, you've got staff and adjusters and potentially a joint pooling organization all being distracted by this aggravating lawsuit. And while the courts will likely tell everyone that this type of litigation won't be tolerated, the fact remains that I'm seeing way too many judges who are giving great leeway to opposing counsel and are refusing to outright dismiss a public entity through law and motion practice. So how do we solve this problem? First of all, you become very aggressive at doing what I call a 1038 letter, and that's using California Code of Civil Procedure Section 1038 to provide a declaration of non-ownership combined with a letter that says you either forego further litigation or we're going to come after you for costs and fees. Now, Section 1038 requires a mandatory award of defense costs, and that includes reasonable attorney's fees when a trial court grants a motion for summary judgment and makes a concurrent finding that the plaintiff lacked reasonable cause and lacked good faith in filing or even maintaining the action against the public entity. Well, that's all fine and dandy when you file a summary judgment. The problem with this type of approach, of course, is that an award of sanctions is against the plaintiff, and you and I both know that usually they're judgment-proof. An award of sanctions against opposing counsel, getting back defense costs and fees, generally isn't going to happen with the court, and there are some who actually argue that that type of imposition isn't even allowed by statute. The other thing to keep in mind when requesting an immediate dismissal or forbearance of litigation against you when you're faced with this shotgun approach to litigation is California Code of Civil Procedure, Section 128.7. This, too, provides us with some ammunition for arguing that we are going to ask for sanctions. This gives us some additional ammunition right at the onset of a tort claim or a lawsuit, because we can point to this statute and then direct opposing counsel to the fact that this tort claim or this lawsuit was done for an improper purpose. It was done to harass you. It was done to create unnecessary delay, and it's increasing your costs and your fees. Additionally, by using that declaration of non-ownership that I mentioned earlier, we are taking away opposing counsel's argument that he or she needs a reasonable opportunity for further investigation or discovery. You want to be very aggressive early on when you get these shotgun tort claims and lawsuits, because it's going to ultimately save you time, save you money, and save you a lot of aggravation. Thank you for joining me today. If you want any more information, you can always go to lawsuitproofyourcity.com. And until next week, here's to us taking back the courtroom together.
You've reached the end of another episode of Lawsuit Proofing Your City with Scott Grossberg. If you like our show, we'd love for you to subscribe, rate our broadcast, and leave a review. You can always check out lawsuitproofyourcity.com for more information and show notes. And remember to go to the archive section on our website for previous podcasts. This podcast is for general information only and not intended to be legal advice nor the formation of a lawyer-client relationship. Stay tuned for our next episode, and thank you for listening.